The Public Order Emergency Commission is now in session. The Public Order Emergency Commission is now in session.
To perhaps rescue or
The Public Order Emergency Commission is now in session. The Public Order Emergency Commission is now in session. La Commission sur l'état d'urgence.
Okay, bonjour, good morning. Bonjour, good bienvenue and welcome to this new phase of the public hearings. Over the last 6 weeks, I've heard from over 75 witnesses who testified about the circumstances that led to the declaration of a public order emergency and the use of powers under the Emergencies Act. These witnesses have provided me with many perspectives on those events, including the views of public servants, police forces, protesters, residents, and political officials. That evidence has been critical in allowing me to discharge the fact-finding portion of my mandate. Nous entamons aujourd'hui la deuxième phase des audiences publiques. Celle-ci concerne un volet différent de mon mandat. Lorsque j'ai été nommé commissaire, on ne m'a pas seulement demandé de faire de la lumière sur ce qui s'est déroulé en janvier et en février 2022. On m'a aussi confié la tâche de formuler des recommandations pour l'avenir. Ces recommandations doivent aborder une éventuelle modernisation de la loi sur les mesures d'urgence ainsi que d'autres enjeux qui méritent d'être étudiés. On m'a également demandé de tirer des conclusions concernant plusieurs domaines spécialisés, des plateformes de sociofinancement à la mésinformation sur les réseaux sociaux. For the next 5 days, the Commission will hear from a series of experts and expert roundtables, each one devoted to a different topic that is relevant to the Commission's policy mandate. These discussions will assist me in making the recommendations that will be contained in my final report. The organization of these roundtables was undertaken by the Commission's Research Council, which has provided the Commission with excellent support throughout the process, including the commissioning of papers. And in that regard, I just wish to note that some of the papers contain factual statements or factual assumptions that may not have been borne out in the evidence led at the hearings. Of necessity, of course, these papers were prepared in advance of the fact hearings, and those factual assumptions or statements will not be considered as evidence and will not be considered in reaching my conclusions. Obviously, I will reach conclusions based on the facts I have heard in the course of the hearings and in the documents contained that were filed. Now, parties withstanding at the inquiry were consulted and provided valuable input on the topics to be addressed, the process that the roundtables should follow, and who should be invited to participate. As a result of that process, the Research Council prepared 9 roundtables involving approximately 50 expert participants. The experts include both academics and practitioners in such areas as such areas of the law as policing, intelligence, and government. For those who have been following our proceedings so far, the policy phase will look somewhat different, both physically and in how it's going to proceed. Rather than examinations by lawyers, the roundtables will start with a facilitated discussion led by a moderator. During this discussion, parties withstanding at the policy phase will be submitting additional questions to Commission Counsel, who will then conduct their own questioning of the participants based on the input received. I too may have questions to ask the participants. Le conseil de recherche, les modérateurs et les participants ont consacré de longues heures à la préparation des tables rondes qui se tiendront cette semaine. Je tiens à les remercier, tous et toutes, d'avoir fait preuve de générosité en acceptant d'appuyer la Commission dans ses travaux. Sur ceci, je cède la parole au doyen Robert Lackey, qui animera notre première séance sur les droits et libertés fondamentaux qui entrent en jeu lors de manifestations et leurs limites. Doyen Lackey, la parole est à vous.
Merci beaucoup, Monsieur le Commissaire. Donc, je suis Robert Lackey, le doyen de la faculté de droit de l'Université McGill. J'ai le plaisir de vous présenter les panélistes ce matin. Brian Bird, Assistant Professor, Peter A. Allard School of Law, University of British Columbia. Jamie Cameron, Professor Emerita, Osgood Hall Law School, York University. Jean-François Gaudreau-Desbiens, Professeur, Faculté de droit et vice-recteur de la planification stratégique et de communication de l'Université de Montréal. Vanessa McDonnell, Associate Professor in the Common Law section of the Faculty of Law, University of Ottawa, also co-director of the U-Ottawa Public Law Centre. Carissima Mathen, full professor in the Common Law section of the Faculty of Law, University of Ottawa. And Richard Moon, full professor, Faculty of Law, University of Windsor. This roundtable aims to lay out the foundation and framework for the fundamental freedoms under the Canadian Charter of Rights and Freedoms. Rights to freedom of expression, assembly, and perhaps association. Protesters regularly exercise these democratic rights, and governments seek to justify limits on those rights. I think there will be consensus on the importance of these rights of democratic participation and the need for sound justifications for limiting them. Beyond that, Commissioner, it's possible that one takeaway will be that reasonable people disagree on the complex challenges of fleshing out and concretizing these rights in our free and democratic society. We have a lot to address this morning, and I remind participants of the need to keep their answers concise. We're going to kick off with a brief primer on the Canadian Charter of Rights and Freedoms, perhaps set against the history of rights protection in this country. Rights have not only been protected through entrenched bills of rights. And so we'll have a little introduction to that, including the notion of substantive rights, limitations on them. And we begin with Professor McDonnell.
Thank you, Dean Leckie. So in terms of setting the stage for today's discussion, it actually does make sense to go back a little bit further than 1982, when the Charter was enacted, and to just touch briefly on Canada's history of rights protection, because we do have a longer history of rights protection in this country. The common law has long protected rights in Canada, and Canada also has a history of statutory protection of rights, most notably at the federal level through the Canadian Bill of Rights, which is an ordinary statute which in the 1960s codified a set of rights and freedoms. Now, this pre-1982 history is certainly not an unblemished one. It's part of a broader history that includes notable failures in rights protection, and so that needs to be acknowledged as well in discussing Canada's pre-1982 history. So that brings us to 1982 and to the Charter, which formed part of a package of constitutional reforms that included the recognition of Aboriginal and treaty rights and a domestic amending formula. So the Charter creates a catalogue of judicially enforceable rights and freedoms. Some of these rights and freedoms are a part of many constitutions around the world. So you'll hear us speak today about the right to to freedom of expression, to the right to equality, the right to vote, possibly. These are all core guarantees that are found in most bills of rights. There are other aspects of the Charter that are unique to Canada, and that would include, for example, the language rights provisions of the Charter. As Dean Leckie mentioned, the Charter is constitutionally entrenched. That means it's supreme law. And that laws that are enacted that are inconsistent with the Charter are of no force or effect. The Charter also prohibits state actors from violating rights, and so that means that state actors must conduct themselves in ways that are compliant with the Charter. And so that brings us to another important foundational point, which is that the Charter binds state actors. And what that means is that the state is bound to respect constitutional rights, but there aren't rights that are held as between private parties. Some of the rights and freedoms that you'll hear us talk about today include the fundamental freedoms, so freedom of expression, freedom of association, freedom of peaceful assembly. These are the core rights that are engaged in the context of a public protest. But there are also rights here that may not be immediately obvious, but which form an important part of the discussion. And so those include Section 7, which is the right to life, liberty, and security of the person, and the right not to be deprived thereof except in accordance with the principles of fundamental justice, and Section 15, which is the right to equality. To the extent that arrests or detentions were made in connection with the protests, the rights of accused persons found in Sections 7 through 14 of the Charter are also relevant. So what do these rights mean? How have they been interpreted? Well, the meaning of the Charter and of individual Charter rights has developed over the last 40 years, largely through adjudication in the courts, but also through the involvement and interpretations of political actors. And I think it's fair to say that in complex situations like the ones that gave rise to the Convoy, there are complex rights issues. And so in discussing how Charter rights were implicated as part of the Convoy, it's important to surface all relevant rights. The rights that were potentially violated as a result of the state response, but also the rights that were protected by the state response. Because I think it's clear that the state, in response to public events like the ones that we experienced, have an obligation to respond in some way. And so I'm going to turn things over to my colleague, Professor Mathen, here in a moment, but perhaps I can sort of set things up a little bit by saying that Charter issues, when they're adjudicated, are adjudicated really in two stages. And so at the first stage, the question is, are rights engaged? Have rights been limited? And if there's no rights violation, that's more or less the end of the story. If a right has been violated, the second step in a Charter analysis is whether any limits on rights have been justified. And so I've really been speaking about that first stage of the analysis, and I'll turn things over to Professor Mathen to speak about the second stage.
Thank you, Professor McDonnell. Professor Mathen.
Thank you very much. Section 1 of the Charter states, the Canadian Charter of Rights and Freedoms guarantees the rights and freedoms set out in it, subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. Its purpose is to guarantee all the rights and freedoms in the Charter and to state that those rights are subject to reasonable limits. Now, the fact that rights would be subject to any limits might seem counterintuitive, but in fact, in most constitutions, there are very few absolute rights. A concern that might be raised about Section 1 in particular is that it appears to undermine the way that we understand something as a right because of its reference to democracy, which might suggest that rights can be reasonably limited if a large enough majority in society wants them to be. Sometimes we refer to this as the tyranny of the majority, the idea that in a democracy, minorities can be vulnerable if they lack political power or are very unpopular. Section 1 does not operate that way. For something to be a reasonable limit, it is not enough that a majority, even a supermajority, really wants that limit. This is because the reference to democracy is not to majority wishes alone, but to a broader conception. What does it mean to be a free and democratic society? Section 1 exists not as an exception to rights based on the wishes of a majority, but as a confirmation that rights are essential in a democracy. Like everything in the Charter, Section 1 is a legal tool. So it has a recognizable and routine framework in place for almost 40 years, whenever it arises in a legal case. The framework both draws on the actual language of Section 1 and how courts have interpreted that language. At the Section 1 stage, the burden of proof is on the state. So it is for the government to convince a court that any limit on a charter right is reasonable and demonstrably justified. Section 1 itself says that a reasonable limit is prescribed by law. This ensures that any limits on charter rights are traceable to an actual legal rule. That rule can be found in statute or regulation, or more rarely at common law. This ensures that limits on charter rights are consistent with the rule of law, which guarantees that all state power is itself authorized by law. Once you start to drill down into whether a limit on a right is reasonable, there are a number of factors that a state will have to address. That the limit on the right is for a pressing and substantial objective, that the limit is rationally connected to achieving that objective, that the limit minimally impairs the charter right in question, and that there is overall proportionality between the positive or salutary effects of the limit and the negative or deleterious effects on the individual whose charter rights have been infringed. While Section 1 is a legal tool designed to promote consistency in how the Charter applies, it's important to recognize that charter rights are implicated in extremely diverse situations of varying complexity. It's also useful to recognize that there is a sometimes delicate relationship between the courts and the state when assessing whether a Section 1 justification has been demonstrated. To that end, the courts have repeatedly stated that the analysis of Section 1 is contextual. It will look closely at the circumstances. While the state must prove its case under Section 1, courts also recognize that it is not always possible to do so to a particular degree of scientific or forensic certainty. This may be because the particular objective really isn't amenable to scientific proof, or because the state is operating in a situation where information is simply not yet available or is uncertain. While purely speculative arguments are likely to fail, the courts do tend to give the state a certain margin in which to establish justification under Section 1, again, depending on the context. The final point I would make here is that it's natural to see the state and individual or citizens in an oppositional, even antagonistic relationship. This is particularly true for some contexts like criminal law, where you have the immense power of the state being brought to bear against a single individual. But sometimes the state is in a different position. It may be trying to balance competing charter rights. It may be trying to protect the vulnerable. Or it may be trying to safeguard certain things or values that in themselves are essential to a free and democratic society. All of those factors may be important to the ultimate assessment of whether Section 1 has been made out.
Thank you very much, Professor Mathen. Does another panelist wish to add anything at this introductory level, our sort of charter primer, so to speak? Professor Moon?
Well, maybe is this on? I can't. Yes, it sounds like it's on. Just add, that was, a terrific introduction. Just add one thing, because I'm struck that often individuals make claims. I have a right to something and make claims at large. And I think it's worth thinking about and noting what's in the Charter and what's not in the Charter. And The Charter, in a sense, performs two functions. One is a symbolic function, and it's meant to list what we understand to be the fundamental rights of members of the political or national community. But it also has a very practical function in the sense that there is an enforcement mechanism. That is to say, if someone feels their charter rights have been breached, they can make a claim for the courts. And that very much shapes what's in the Charter and how particular charter rights are, in fact, interpreted. The limits of what a court can do and how a court can approach or interpret a right. And I just think that's worth noting, given the general language it often operates about I have a right, statements made very much at large.
Thank you, Professor Moon. Okay. Commissioner, we're going to move on. And so a few minutes from now, we're going to drill down more specifically on two of the fundamental freedoms, freedom of peaceful assembly in paragraph 2C of the Charter and freedom of expression in paragraph 2B. Still in a somewhat introductory mode, we're going to speak a little bit about those rights of democratic participation together, perhaps connecting them to fundamental values of public engagement and participatory democracy. And we're going to continue now with Professor Bird.
Thank you very much, Dean Leckie. So the topic of democratic participation, how and when individuals who belong to a democratic society contribute to the democratic governance of that society, raises several complicated and nuanced considerations. Participation in a democracy can take many forms: voting, running for office, writing to your elected representative, starting or joining a political advocacy group, and so forth. But for today, our focus is on protest as a form of participation in a liberal democracy, the idea of a right to protest in such a society, and when that right can or should be limited. So in these brief remarks, I'll offer some reflections on the added value of protest in a liberal democracy, leaving the matter of a legally protected right to protest and how that right can be limited for a later stage of our discussions. So it seems rather uncontroversial to suggest that protest in the form of rallies, marches, demonstrations, sit-ins, etc., is part and parcel of democratic life. Protest may at times test certain commitments that are said to be hallmarks of a liberal democracy, but I think it would be difficult to find widespread support for the notion that peaceful, nonviolent protest is untethered to democracy, or that this activity should be done away with as a form of democratic participation. And in general, I think the occurrence of protest is a marker of a vibrant democracy in which citizens are invested in how they're being governed and how their society ought to change. Even where protests might be a response to a perceived departure from democracy, these protests are still a form of democratic participation as they aim to perhaps rescue or preserve democracy and democratic institutions. Citizens coming together to publicly manifest their support for or opposition to this or that cause, issue, law, court decision, or some other current issue of public interest is a normal feature of democratic life. So much so that it would be perhaps unsettling from the perspective of a society's democratic credentials if protest were to become an endangered species of democratic participation and even extinct. And that idea invites us to think more about the added value of protest to our society, to a democracy. It's one thing to say that protests are commonplace and accepted as normal in a democratic society, but how do they enhance the practice or project of democracy? And perhaps history and hindsight might help us here. It wouldn't take too much time to be able to create a list of protests or activities akin to protests that were either instrumental in effecting transformative change for a society or significant from the perspective of raising within that society, and perhaps in other societies that take notice, of injustice, inequity, or violations of human dignity. So the civil rights movement in the United States, for example, comes quickly to mind. Now, scientific measurement of the effect of protests like these on the societies in which they occurred, as well as on the other societies that may have taken notice of those protests, is difficult to provide. But it seems fair to suggest that these and so many other protests over the course of history have accelerated the pace of change in hearts, minds, and laws alike. So the value of protest in the pursuit of a society that is more just, equitable, and protective of human dignity might be easier to perceive through the rearview mirror, so to speak, but we can choose to apply these lessons of the past to protests we witnessed during our lifetime. The protests we ourselves witness could be part of a longer arc of positive change that is not entirely perceptible to us at the time the protest is occurring. They may also turn out not to be part of that kind of change, but our inability to definitively know either way when the protest is underway suggests that we should perhaps err on the side of permitting protest. Still, some of us might say that instead of protesting, we should opt for less disruptive and disconcerting forms of democratic participation. Voting in elections, writing to your elected representative, publishing an opinion article in the newspaper, launching media campaigns for a cause, and so on. And one response to this proposal would be that protest, owing precisely to its uniquely disruptive and perhaps disconcerting characteristics, may in certain cases be far more effective than other methods of democratic participation. It may even be true that in certain cases, protest is the only method that stands any chance of sparking the change that is desired. It's hard to imagine, perhaps, the civil rights movement in the United States of having succeeded simply through writing letters to members of Congress. Protest, in other words, might be the only meaningful way for certain voices and the message they carry to be heard by individuals in the halls of power. Without protest, the desired change might take longer to come about, in the order of years, decades, and even longer, or the desired change might never come about. Much more could be said about the added value of protest to democracy, not to mention the value of protest to the human condition and spirit. But for the sake of time, I'll mention only one more now. It could be called the pressure cooker rationale, allowing citizens to come together to peacefully express discontent over how their society or other societies are governed, allows these citizens, and even those citizens who agree with the protest but can only watch on television or social media, to let off steam and be heard. Forbidding or unduly expressing this outlet for citizens might sooner or later cause the pressure cooker to explode. Just to close, perhaps the greatest obstacle to appreciating the democratic value of protest is our own personal opinions on the aim or cause of a particular protest. When we disagree with the viewpoint animating the protest of the day, our opinion of protest as a form of democratic participation may also diminish. And the reverse also might be true. When we agree with the complaints of the protesters, our affinity for protest itself may increase as well. And this dynamic seems to come to the surface when we opine on how long a given protest should be allowed to last, or the degree to which restrictions should be imposed on the time, manner, and place of the protest. I suspect we often afford more or less latitude on these points, depending on how sympathetic we are to the views animating the protest at issue. And to close, I would just note that it takes a major dose of even-handedness and tolerance to express support for peaceful protest, even when we vehemently disagree with the reason for this or that protest or the views that the members of the protest hold. And yet, in Canada, this ideal, this even-handedness and tolerance, seems to be our aim in a free and democratic society committed to maintaining a public square that is open to all its citizens and, apart from exceptional circumstances, the unhindered expression of their core convictions. So I hope these reflections will aid our conversation today as we explore how protest is and should be protected as well as limited under Canadian law. Thank you very much.
Thank you, Professor Bird. I wondered if any panelists wanted to comment on the particular contributions of any particular protest in recent years, qu'il s'agisse du printemps d'érable ou quelque chose d'autre comme cela, at this stage. Does anyone want to jump in on a particular? I have another. After that, we'll move to the connection, perhaps, between a couple of the democratic rights of participation. Professor Cameron?
Yes, thank you, Dean Leckie. I would just draw attention to the pedigree and lineage of protest movements in history. So not expressly to answer your question, but just to point out, if we're looking at the United States, for example, we go back to the time before the Civil War and to the whole abolitionist movement, followed by the women's movements, and then up into the civil rights movement, which has been mentioned by Professor Bird, as well as Vietnam protest and any number of others. In our own country, just in recent years, we have seen Maple Spring, of course, the Occupy movement, Black Lives Matter, Idle No More, Pride movements, and all the Indigenous movements, which are too numerous to mention. But just to say that we have a very strong pedigree of protest movements in North America and including in Canada. And they're an important aspect, I agree with Professor Bird, very important aspect of participatory democracy.
Thank you, Professor Cameron. That makes a little more concrete Professor Bird's reminder that protests may not be simply something to be tolerated, but that they bring a distinctive value. Professor McDonnell?
I was just going to add that I think that you've both captured very well the sort of value of protest in a democratic society and the importance of nurturing it. My sense is that where the challenge lies is in, first defining the contours of a right to peaceful assembly, but then also sorting out how the state should respond when a protest implicates the rights of others. And so I think there is a wide degree of consensus on the value of protest in a democratic society. What becomes genuinely challenging is how the state responds in circumstances where parts or all of a protest become violent, where a protest interferes to some degree or to a substantial degree with the security and safety of others. And so I think the real challenge for decision makers, whether that's the state in the first instance or a court on judicial review or an inquiry reviewing these matters, is how do we do what Professor Mathin alluded to in her discussion of Section 1, which is how do we balance the competing rights and interests that are at stake in the context of a public protest? And to me, that's where the difficult work is.
Thank you, Professor McDonnell. Professor Moon?
Yeah, I think, and I know this, comes up in the various presentations, we have to recognize that any kind of protest is invariably disruptive. It will, to some extent, interfere with the ordinary use of spaces, people's ordinary lives. And so again, I agree, the challenge is to determine what is the outer limit of that? When does it become too disruptive, either as a matter of how much space is taken up or how long it's going on or how confrontational it is? And there is no simple answer to that. I think that's the real problem. One can think of the Occupy movement, for example, which involved the establishment of encampments that were there for an indefinite period of time. At least that seemed to be the plan. Everybody accepted that it was an important protest and that there was a right to be located there for a period of time. But then the question became, well, how long is too long? And again, there's no simple answer to that question.
Thank you, Professor Moon. Part of the challenge of construing a Bill of Rights, such as the Canadian Charter, is seeking to identify the relationship between the different guarantees. And at times we see from the claims brought in court that there's a perception that multiple guarantees may be engaged by a similar set of facts. But nonetheless, conceptually, it can be helpful to try to distinguish the different guarantees. And in the discussion so far, we've been touching, I think, on peaceful assembly and perhaps freedom of expression. Does any panelist want to prepare us for the challenge of articulating or separating those two before we go into them one by one? Professor Cameron?
Well, I think that was part of what I had been planning to say. I can do it up front if that's preferable. So I guess I would say that the fundamental freedoms overlap and complement each other, and that you couldn't have a viable freedom of peaceful assembly without also respecting protections for freedom of expression, and I guess, incidentally, freedom of association. So they work together and they have to all be protected, but I would also say that freedom of peaceful assembly is a distinct and independent guarantee that is not the same as freedom of expression. And so I can go into that in a tiny bit more detail. freedom of peaceful assembly is a collective entitlement. It's an exercise of solidarity by a group of two or more individuals. The Supreme Court of Canada has acknowledged as much. It hasn't discussed Section 2C very much, but it has acknowledged that it is a group activity that is incapable of individual performance. So we tend to think of Section 2B, freedom of expression, as being an individual entitlement, and perhaps Section 2C is as well, but it's one that is exercised in collective, in a collective way as an embodiment. I think that also it's important to note about freedom of peaceful assembly that it has an embodiment and a presence that is usually spatial in nature. Not necessarily the case with freedom of expression. And then assembly is also, I'll use this word, it's performative in nature, in the sense that what you have with an assembly is more than verbal expression. And whether the assembly is passive, like forms of assembly can be completely passive, that can be the message. And assembly can also be active and indeed very active. But what this tells us is that the act of assembling itself has a performative nature and a meaning that is not captured by Section 2B's freedom of expression. And therefore, it would be a mistake to collapse Section 2C and the right of peaceful assembly into Section 2B and treat assembly events as belonging under Section 2B rather than having their own independent entitlement. And so, from my point of view anyway, it's very important to separate Section 2C from Section 2B and begin the task of giving it definition and interpretation. So I don't know if others have comments on that. But.
Thank you. So you're, Professor Cameron, you're laying the groundwork for us to move in a moment to go a little deeper into looking at freedom of peaceful assembly, which, as you note, has been construed less by our courts than have others, freedom of religion, freedom of expression. At the level of the rights of democratic participation together, is there a final thought from anyone? Okay, so we're going to go back to Professor Cameron to pursue our reflections on freedom of peaceful assembly.
Don't worry, Dean Leckie, this is where it gets lively. Okay, so the Charter's guarantee of peaceful assembly has been mostly inert for the first 40 years of the Charter's interpretation. There's been very little in the jurisprudence, and apart from a mention by the Supreme Court that I noted a moment ago, has had very little interpretation or discussion at the Supreme Court level. And this might seem surprising, given what we've just heard from Professor Bird and others about the importance of public protests and public gatherings and their value as a form of participatory democracy. And I think it's clear that the Charter's fundamental freedoms and peaceful assembly do form a vital background to the Commission's work. So some may know that I did write a commission paper for the Commission on peaceful assembly. It's on the website. And the purpose of that paper, at least from my point of view, was to bring peaceful assembly into the conversation. And the paper, therefore, does not discuss the convoy or make any assessment of convoy activities, but its objective instead was to propose an approach to Section 2C. So here I think I'll quickly just make 2 or 3 points and then move the discussion back to colleagues who I know would like to weigh in on how we look at peaceful assembly. So I've already spoken about peaceful assembly as an independent guarantee of the Charter, and I've spoken about the importance of recognizing that entitlement and giving it its own place in the Charter. That was point number 1 in my presentation. So I'll move to the second point, and we heard about the structure of the Charter from Professors McDonnell and Mathen, and I think I'm going to start there because it's very important when we start to take a look at Section 2C, it's very important to have that structural framework in mind. And as Professor McDonnell told us, there are 2 steps in any charter analysis. The first step is to look at the nature of the entitlement and to give that entitlement a definition or interpretation. And then the second task is under Section 1 is to determine what limits are reasonable, what limits on that charter entitlement are reasonable.
Professor Cameron, this is super valuable stuff. If you could slow down just a little bit, it would help the interpreters and the broadest audience you deserve for this.
My apologies. Should I go back over any of that?
But just
okay.
Tiny bit slower.
All right. So then looking at that structure reinforces the view that peaceful assembly, like the other fundamental freedoms under Section 2 of the Charter, should receive a generous interpretation. And so that means that questions about limits on peaceful assembly, for the most part, should be found and imposed under Section 1 rather than introduced into the preliminary definition of the entitlement. And in other words, peaceful assembly should be given broad coverage and limits to deal with disruption, disturbance, those kinds of issues should, for the most part, be reserved for Section 1. That's the setup and the nature and the concept of the Charter. So moving to Section 2C specifically, the central question under Section 2C, I think it's fair to say, is what is the meaning of peaceful assembly? What does it mean to say that an assembly is peaceful in nature? So what is peaceful under Section 2C and what is not? And I think there are going to be different views on this. And I'll just tell you a couple that I encountered in preparing the paper. And I'll say first that how you answer that question, how you decide what peaceful means for purposes of Section 2C will have dramatic consequences for the scope of the entitlement. So it's the critical issue under Section 2C. It is the critical issue for peaceful assembly, for that entitlement. So one approach to the question of what is peaceful equates peaceful assembly with nonviolent assembly. And under this view, assemblies are considered peaceful unless they engage in acts or threats of violence. It doesn't mean that limits can't be imposed under Section 1, but it means that an assembly has prima facie or preliminary status under the Charter as long as it does not engage in any violent activities. That's one view. It's not the only view. There's a different approach, sees it a different way, and would interpret the meaning of peaceful assembly quite differently. So under that view, an assembly is not peaceful or non-peaceful when it does any of the following, like cause a disturbance, engage in disruptive activity, engage in objectionable conduct, and even violate bylaws and other kinds of legal regulations. So on that view, an assembly would become non-peaceful when it reaches a sufficient threshold on any of these criteria. And under that view, it would mean that the assembly does not have any protection under the Charter. The difficulty with that view, in my opinion, is that it creates a risk of prematurely or preemptively shutting down public gatherings or demonstrations because they are considered or experienced as being objectionable in nature. And the risk is that the messages of the dissidents and vulnerable will be too quickly cut off. Now, we don't have a lot to go on in Canada. We do not have any Section 2B jurisprudence to speak of, much less a robust jurisprudence. But the international jurisprudence on these issues is quite striking, because under the international guarantees, peaceful assembly is protected up to the point of violence. And the issues about disturbance, disruption, commission of unlawful conduct, etc., are matters of limits under their version of Section 1 or proportionality, but not of initial entitlement. I'm going to mention a third approach, and I'm going to give a bit of a shout out to the City of Ottawa, who provided, the City of Ottawa presented a brief in response to my paper, and it's a thoughtful response. The City of Ottawa, as I understand their response, proposed a harm test for Section 2C. So the idea was that violence is at one end of the spectrum, disruption considered still a form of peaceful assembly is at the other, and the city placed harm as a test sort of between the two. And the idea of it is that once a certain threshold of harm is reached in the activities of an assembly, that will forfeit the protection under Section 2C. So that was proposed as an alternative to these other two understandings of peaceful assembly. I guess I would say that it's difficult for me to agree with the City of Ottawa, although I think the proposal is certainly worth discussing. It's difficult for me to agree with that because harm is a very subjective and evidence-based concept, and it's better suited to the kind of analysis that is typically done in Section 2 cases under Section 1. So I would see a harm analysis under Section 2 as being out of keeping with the way Section 2 analysis is done generally in Section 2 cases. And again, a malleable concept of harm runs the risk of preempting assemblies that are engaged in participatory democracy. I'm coming to pretty much my last point about Section 2C, because I know we want to open the discussion up. And this is also a really important point, I think. We need to think about the relationship between the assembly per se and the individuals who are participating in the assembly. So I've mentioned that the assembly is conceptualized as a collective entity. But the collective entity, incorporates various numbers of individuals. The constituent participants in an assembly remain responsible for their actions. So, for instance, if members of a public demonstration or protest engage in unlawful conduct and even violate the criminal code, they are responsible in their individual right for their actions. They're responsible for any unlawful conduct they may commit. But generally speaking, and it's subject to evidence, of course, generally speaking, the acts of individuals do not taint or compromise an assembly, unless those acts become so pronounced or so pervasive that they come to define or characterize the assembly. At that point, they become the assembly, and that may change the status of the assembly under Section 2C. I'm just going to, I think I've given us some things to think about. I'm going to make one final comment, and it is a little bit about this particular demonstration, but just to illustrate, I guess it would be my view that the assembly in this instance began at the point when the convoy set out from British Columbia at the start of the convoy. Trucks were at that point integral to the assembly, and it was for many days, it was a moving assembly. It was an assembly that moved across the highways in Canada before arriving in Ottawa. When it arrived in Ottawa, it became static and embedded. The trucks may still have been part of the assembly, but maybe their role changed. And maybe their presence in Ottawa changed and even escalated the nature and scale of the assembly. I think it would be fair to say, and I hope I'm not overreaching, Mr. Commissioner, I think it would be fair to say that the trucks compounded and intensified the disruption. But what I would say is that on a principled approach to the structure of the Charter, those issues inform the analysis under Section 1 rather than the scope of entitlement under Section 2C. And I have things to say about reasonable limits, but I think I've spoken enough and would love to hear from my colleagues.
Thank you very much, Professor Cameron. So just to situate your very helpful comments for the audience here, you were really focusing at defining peaceful assembly at the paragraph 2C level, basically bracketing for other discussion the question of reasonable limits on peaceful assembly under Section 1. And you were very helpfully, I think, focusing on the qualifying adjective peaceful, and it's 2C is distinctive in that the other fundamental freedoms don't have a qualifying adjective. So we have the right to freedom of religion with no adjective, freedom of expression, freedom of association without a qualifying adjective. So it's a real invitation to understand what that peaceful is doing there. And you've invited us to think about the three approaches there. I remember from our preliminary discussion with several panelists that there may also be questions about even what an assembly is and to what extent an assembly is focused on natural persons and appendages immediately within their control versus larger dimensions. But let's open things up. I think Professor Mathen, you had some thoughts to share on this one too.
I do, thank you. And I really enjoyed the policy paper prepared by Professor Cameron, and I just do have a few observations that build on the paper. So the first point is I entirely agree that we do need to recognize assembly as an important fundamental freedom in its own right, and particularly in the relationship with expression, while they overlap, they do reflect different components of a free and democratic society. To that end, though, when we think about assembly, as Dean Leckie has just noted, it does have this, what we call an internal limit, an internal qualifier, which is the word peaceful, which is not, we do not see that with the other fundamental freedoms, and so our analysis needs to take some account of that. In terms of looking at the right itself, while it often is associated with meaningful activity, I think we might want to be careful that we don't only see assembly as oriented towards conveying meaning, because it is a physical activity. It can be addressed towards some other goal that is not closely related to conveying meaning. For example, an assembly could be oriented towards protection of an individual or a place that is really its own goal, separate from any conveyance of meaning to other people. In terms of the word peaceful, I think here as well it is important to recognize something that distinguishes assembly from the other fundamental freedoms, which is that it is commonly manifested in a physical way. So it is the coming together of people, and it is that physicality that historically, of course, has been seen as very important. But that also makes assembly different from the other fundamental freedoms. And so when we think of the limits on peaceful, I think that the borrowing from expression of the freedom of expression, but in addition, how we assess what the threat is, I think may require a slightly different vantage point, which is that I think it is useful to consider using an objective analysis of the threat posed by a particular assembly that may take it out of the protected sphere of being peaceful. So this is not dependent on proving the violent intentions of any one of a number of the members of the protest, which I think is first of all, can be extremely difficult to do, but also does not sufficiently engage with the nature of the protest as a whole. So this is not a numbers game. This is a very fact and context sensitive assessment of what the assembly is or is becoming. It might also be interesting to consider, just as there is a right against forced expression, is there a right against forced assembly? And again, because of the physical manifestation of assembly, are there circumstances in which people might be involuntarily brought into the context of the assembly? And this might particularly be the case where the nature of the assembly is such that it actually affects the person in their primary residence, so that in order to escape the effects of the assembly, they must leave their residence. Is there a question about whether you are in that context, perhaps dealing with involuntary or forced assembly? Dean Leckie noted the very interesting question of what the actual fundamental freedom includes in terms of whether it is just human bodies or other things. And that, I think, was very much brought out in the current situation that we're considering. And the one point I would make there is that, and this is not, I would think, as to whether the assembly is peaceful, but whether it is actually a protected exercise of assembly. We just want to be careful that we don't overread the right of assembly so that it privileges those who have more resources to effect an assembly that becomes more difficult to control. So I would just perhaps suggest that that might be something to think about. And then finally, when we get to the justification section under section 1, certainly the state should be cautious about simply dispersing an assembly. I believe in international law that is seen as a last resort. But in some contexts, dealing with the assembly more rapidly may actually create the space for maximum enjoyment of the right of assembly going forward, as opposed to, because of this very, I think, appropriate reluctance to interfere with the assembly, what you wind up producing is a situation of an entrenched assembly that then has to be dealt with in a much more intrusive way. So I'll stop there.
Comments from other panelists at this point? Professor Moon and then Professor Bird. Professor Moon.
Okay, thanks. Just a brief comment. Professor Cameron's paper is a terrific paper and really outlines a very strong argument. I want to take not exactly issue with it and some of what Professor Mathen has said, sorry, I almost got that wrong. And I want to kind of reassert that what I think is a significant overlap between the different rights. It's really important to remember when talking about freedom of religion, for example, it has a collective dimension. It protects religious rituals, manifestations of religious practice, often which occur in collective form. And so it does have a physical dimension to it in that sense. And the same could be said about freedom of expression. Expression occurs in a variety of ways. I'll say something more about that in a minute. But it's always physical, even in the most minimal sense of using one's vocal cord, but more often involves much more than that. So I want to reemphasize that all of these rights have a physical dimension to them. All of them have a collective dimension to them as well.
Thank you, Professor Moon. Professor Bird.
Just a couple of quick comments. Thank you, Professor Math and Professor Cameron, for all the comments so far. In listening to more recent remarks, it does seem to me that this addition of this adjective of peaceful, I've so far drawn to this notion that perhaps the drafters are trying to point us to, in a way, what it doesn't protect. And in that, just thinking of the kind of natural antonym of peaceful being violent or violence, so it doesn't protect violent assembly. But I need to think more about this, and the comments are making me think more about that. One thing I would also note that this approach has been suggested by the City of Ottawa, perhaps using harm and as a kind of a way to assess whether the assembly is protected or not. It does seem to me that, at least just from an application perspective, that determining what's violent as opposed to non-violent seems to be a bit more manageable or easier to identify, perhaps, than harmful versus not harmful. So even from in addition to the kind of just the linguistic, the text, what it may be pointing us to what the protection does not cover. I'm also drawn to the notion that harm is just indeed has seemed to be a very difficult or can be a challenging concept to apply, whereas violent versus non-violent seems to be maybe a bit of a brighter line. But I just wanted to mention on the Section 1 standpoint, this idea of limiting peaceful assembly, just given what has been said so far about the value of assembly and protest to democratic participation, one of the lesser kind of interpreted phrases in Section 1 is this idea of a free and democratic society, this notion that all rights and freedoms in the Charter can be limited when those limits are prescribed by law, when they're reasonable limits, and then finally when they're demonstrably justified in a free and democratic society. Perhaps this discussion also invites us to think more about what that phrase, free and democratic society, especially the democratic part, means in terms of, does that somehow animate the threshold or the bar which the state needs to reach? And even the word free as well, given that that word points to, has a particular resonance with freedom in the fundamental freedom. So just maybe thinking a bit down the road of our discussion of Section 1, that phrase of free and democratic society seems to potentially have a lot of, may have much to say, or a lot to say in this context. I'll just pause there.
Professor McDonnell's next, and then we'll go to Professor Cameron. Professor McDonnell.
Just a short point on this question of reasonable limits on freedom of peaceful assembly. I think in thinking about reasonable limits, it would be helpful for us to try to move beyond what I think is a very common binary in our thinking about protests, which is you either allow the protest to continue or you shut the protest down. And one of the important components of the Section 1 analysis is to examine whether a limit on rights is minimally impairing, whether it impairs no more than is required to meet its objective. And it seems to me that there are points on the spectrum that our discussion often fails to capture. And so you do see, if you look at the very little bit of case law that there is on freedom of peaceful assembly in Canada, that one option is to allow an assembly to continue during specified hours or under different conditions than the assembly, than the conditions that originally surrounded the assembly. And so to me, this sort of moves our discussion away from either full protection of this right or sort of full violation of this right to a space where we can consider, is there a way to still give meaningful effect to freedom of assembly while also recognizing that, as Professor Moon said, as time goes on, if there are elements that are potentially violent or, highly disruptive to the safety and security of others, are there options there that still allow for substantial preservation of the right?
That's very interesting, Professor McDonnell, given Professor Cameron's point that dispersal is the absolute last resort, right, but it's not the first mode of intervention. Professor Cameron.
Yes, just thank you, Dean Leckie. Just a couple of follow-up points. On the issue of acts or threats of violence, I think that it's helpful to think about the nature and the level of the threats, to ask where they're coming from, who is making those threats, if any, and how pervasive they are. because the threats will typically be made by individuals rather than the assembly. And, oh, excuse me, the entitlement belongs to the assembly. So we have to be careful not to treat levels of disruption as threats in and of themselves, because to do so risks excluding certain assemblies and gatherings from Section 2C and not granting them any charter protection at all. So I would always argue that those kinds of limits can be imposed under Section 1. So it's evidence-based, whether there are threats, whether they're sufficient to compromise assembly. A second point has to do with Dean Leckie's observation, and I guess a discussion we had at dinner last night, which is what exactly is the assembly and what kinds of props that may be used or by an assembly are included in the entitlement. And so we specifically had a question about trucks last night and whether they are part of the assembly. But there are other kinds of examples, of course, so that assemblies choose the way and means that their message can be effective. So they will typically, or they may use all different kinds of props. And they can be quite innocuous in nature, the props that are used by assemblies, but they can go all the way down to the use of weapons and so forth. So the question there is, to what extent does the right of peaceful assembly include the choice of means and the choice of props and structures, including not just camps and entitlements and tents and camps and so on, but things like trucks. And a final point just has to do with the relationship between Section 2C and Section 1. I think, we may have reasonable disagreements about whether the work can be done under Section 2C or whether it should be reserved to Section 1. One of the reasons I support the Section 1 approach is that, for the reasons that were just mentioned, that it's not an all or nothing kind of a calculation. There may be ways for an assembly to continue in a proportional way with the imposition of limits that carefully balance the rights of the community. I think I'll stop there. Thank you.
Thank you. Professor Mathen.
Thank you very much. It's just a brief point to just to clarify perhaps the issue around threats of violence. And I just want to be clear that I am here talking about violence against the person. So the classic criminal understanding of violence against the person. So that is interference with people. Those are the kinds of threats I was talking about, not other forms of disruption. But there can be, on an objective basis, an assessment that the nature of an assembly creates a reasonable generalized threat to people who are within the immediate vicinity of that assembly. It will be very much fact specific.
Thank you. It's also interesting to grapple with the question, at what point do individual members of the Assembly start to characterize the thing as a whole, such that we feel that the Assembly itself is involved in conduct of that nature. One of the questions submitted in advance to us concerns specifically Canada's Indigenous peoples. And so I wondered if panelists had thoughts on whether the fundamental freedoms of Indigenous peoples differ from those of others, particularly when they involve social movements seeking to promote recognition and respect for traditional territories, lands, and resources. And a more specific form of that question, should the Charter protections for assembly and protest be interpreted consistent with the rights of Indigenous peoples? And is Section 25 of the Charter any help in this regard, so that limits imposed on those fundamental freedoms do not restrict Indigenous peoples from obtaining redress for historic and ongoing violations and denial of their rights? Anyone wanting to take that one on?
I can just say
Professor
a few words.
Gautreau-Desbiens.
if we look at the case law of the Supreme Court, for example, on freedom of expression, we realize that when the court looks at Section 1 and at the justifications that are invoked to defend some measures, potentially restricting freedom of expression, it's a context-based analysis which takes into consideration particular situations. Example, the cases involving the Charter of French Language in Quebec. The analysis that was made by the Supreme Court was responsive to the particular context of the French language in the province of Quebec. So under Section 1, I don't see why cases involving the fundamental freedoms of Aboriginal people should not be treated in the same sensitive way. Canada is a very diverse country, and in many cases, the Supreme Court has clearly taken into consideration differences. For another case involving Quebec, where the particular regime of and history of labor relations in the province was taken into consideration, absent this consideration of the particular context of the province, would the decision have been the same? I don't know, but being context sensitive, as the court has been in its application, its interpretation of fundamental freedom, and the evaluation of their reasonable limitation, is part and parcel of our case law and of our constitutional law. So I don't see any fundamental problem in being context sensitive to the claims of Aboriginal people and their rights.
Thank you. Commissioner.
Yeah, I just want to, not on this last point, but go back to a point that Professor Mathen was raising, and that's about peaceful assembly and the question of whether it's a matter of violence or threatening. And I think threatening is very relevant if in this case, because we heard a lot of evidence about people who felt threatened by the fact that there was all this gas around and they were scared for their life, arguably. There were people who would not walk to work because they felt threatened. And there were businesses who closed because of the threat of mask removal and so on. So leaving aside whether those facts are established or not, which is a dispute, and leaving aside really whether that's a group of individuals or not that were causing it, I'm quite interested in exploring a little more that concept, because whether that means it's a Section 1 or whether it's the assembly is peaceful. And I think the peaceful is if violence is the only thing that makes it non-peaceful, that's one thing. Although I don't think that's a big limitation, given that violence is illegal per se, and when is the assembly violent would be hard to define in any event. But so that would be helpful for me, and because I think that's part of the concept that is being developed.
Thank you, Commissioner. And just before we go back to the panelists, I would just add to that, if I might. I'm wondering if anyone else wishes to take up Professor Mathen's suggestion that at a certain moment, an assembly is actually conscripting other people into participating in it by being, in their neighborhood all the time or something like that. And so we know in other contexts that one is not allowed to impose one's religion on others, that one has a certain right not to be in an association. And so I'm wondering if anyone else finds it helpful as a distinct question from whether violence has occurred to say at a certain point, I have no choice but to be part of this assembly. And does that help us see a limit on the right to peaceful assembly? Now, Professor McDonnell was already on my list, and I see Professor Cameron will follow her.
I was on the list for a slightly different point, so perhaps I'll just cede my time to
Sure.
Mr. Cameron.
Professor Cameron?
Okay, so just a couple of points, if I can read my writing. Thank you, Mr. Moderator. So I think there's a difference between threats of violence being made and the community's experience of feeling threatened by the presence of a gathering or a demonstration. And so again, in the spirit of not preempting a fundamental charter entitlement, I would say that that experience of feeling threatened can definitely be addressed. And there's nothing to say that it doesn't allow limits. But my view would be that that belongs under Section 1 rather than Section 2. I think also, again, with second point, I'm not sure this is responsive or not, but it's a messy situation, isn't it? Because you have an assembly that can be sort of inchoate, and you don't really know what is the who is the assembly, what is the assembly proper, and who are the interveners, and to what extent is the burden on the state and authorities to separate out those who have gone rogue or engaged in their own activities of unlawful conduct? I think that's a difficult question. Again, the concern would be not to preempt the entitlement needlessly unless the evidence permits a conclusion that the assembly has itself attained violent dimensions. And then a third point was about being conscripted, but I'm going to pass so that others can speak.
Professor Bird, then Professor Mathen.
Maybe just on the conscription point, or imposing one's assembly on another, it does seem to me that the built into the protection of the guarantee is this notion of kind of voluntary assembly, of you wanting to be of your own free will and not under duress or not coerced or conscripted, being a member of that. So I think the notion of not imposing one's religion on another in terms of the freedom of religion context does seem to have a lot of purchase here as well. On the question of threats of violence, strikes me that if an assembly is occurring and it's public and the authorities are aware, of course, can monitor for prospects of violence. Is there a point at which the threats of violence have transformed into where the violence is inevitable? The authorities know that it's going to occur. Maybe they have intelligence that they know that it's going to occur on a certain start at a certain date and time, or they have very strong evidence or objective grounds for that. You could arguably say at that point that maybe it is now no longer peaceful, such that it's no longer captured by the guarantee. Alternatively, it could be seen as still being peaceful because the violence hasn't yet started, and any kind of intervention, which might well be justifiable to avoid what is violence that is forecasted to start, would be indeed a limit on a still peaceful assembly, but one that would be considered under Section 1. So I'll just pause there.
Thank you. Professor Mathen.
Thank you. I think a really important point about freedom of peaceful assembly and I take Professor Moon's point that there are aspects that are common to all the fundamental freedoms, but linked to Professor Bird's discussion of democratic participation is the very important component of mutuality among citizens when they are confronting the kinds of issues that arise that will be the subject of some exercises of peaceful assembly. And so that mutuality, I think, is very important. And it's in that context as well that it becomes important to assess the overall nature of the assembly, which may be very messy, which may have inchoate or unknown leadership, which may have multiple assemblies. But from the objective point of view, that doesn't make it impossible or indeed remove the need to arrive at an assessment of what the assembly is and the potential risk of interference or level of interference with other citizens that, again, takes it out of that umbrella of being a peaceful assembly protected by the Charter, consistent with the underlying norms and purposes of the Charter that warrant this constitutional protection.
Thank you. Other thoughts from the panelists?
Just
Professor Cameron.
Just one tiny point, which is what Professor Mathen is speaking to, I think, is the coercive properties of demonstration in certain circumstances. And I guess I'm just thinking through, and I don't have anything further to say at the moment, but there may be a difference between something that is sort of a coercive presence versus a threatening presence. And, you know, it's a point to sort out.
Thank you. Professor McDonnell.
One small point just in making this, you know, sort of factual assessment of the nature of an assembly. I think that that social media makes this more difficult in some ways because Professor Bird talked about, you know, what police intelligence might be available. Is there national security intelligence that's available? You know, I think there's also this question of how the protest is understood in the public, in the media. And on social media, there is the potential for a small number of leaders to really to be the face of a protest. And so I think one of the challenges in trying to make this objective determination is, you know, what matters? Is it what's happening on the ground? Is it what the, you know, the police information tells us? Is it what seems apparent on social media? And, you know, in many ways, the democratization of social media has been very positive. I think it can also, though, perhaps like skew our assessment one way or the other, frankly, in terms of trying to characterize the assembly as a whole. And given that this plays an important role in determining the scope of constitutional protection, I think that that is something worth reflecting on.
Professor Bird.
Just building on Professor McDonnell's point, I think that's very important. The kind of social media face or the media face of an assembly versus the true, that's potentially different kind of situation on the ground, or perhaps the skewing effect that you talked about seems a very important factor. And I just wanted to qualify my remarks a little bit before when I said that if threats of violence are risen to the level of now they're going to be inevitable, the violence is going to occur or is expected to occur, it may not be that it animates the entire assembly. It may be that, you know, out of an assembly of 1,000 people, there is evidence that 5 people, whatever the number might be, a very small percentage themselves, are going to kind of go rogue, so to speak, and enter into violence, while the rest of the assembly has no interest in that whatsoever. So that's another part of the conclusion as well, is, you know, do you then have a more individual kind of focus and holding those individuals accountable and saying that the assembly still, by definition, is still peaceful? Or do you say that it's now become, in the grand scheme of things, an unpeaceful or non-peaceful assembly across the board? So that's another consideration to bear in mind. Thank you.
Thank you. Commissioner, have we provided some help on the question you asked?
Yeah, some help, but it's still, I'm still troubled. I mean, to put it more dramatically or more sort of black and white, at sort of 10 o'clock on the Saturday of this demonstration, certain people have said it's an occupation. And so my question is really directed at that, and leaving aside whether that's a fair characterization, but a neighborhood was occupied. The police, to a large degree, were not pressing any charges, were not pursuing any complaints by the citizens of that area, and arguably there was no real violence in those areas that was reported. Let's assume that. So that's really my question, is you have an occupation of a neighborhood as opposed to a park, and you have people who legitimately, let's assume, and they've testified they felt threatened. You can't point to any violence. Do you have to go to Section 1, a reasonable limit, i.e., which is, I think, what Professor Cameron says, or is there something about peaceful assembly? No, you can't. It's not a peaceful assembly to occupy a neighborhood and basically where police can't enforce because they'll be swarmed. Again, you might say it's a few individuals, which no doubt it is. But I think that's a factual finding I may have to find, but it's, when I look at peaceful assembly, is that something that is peaceful? But again, I thank you for the comments, but I wanted to point out really what is a critical element in this is that occupation, as it's been described, where it's been said it's a lawless neighborhood in which people live, and no suggestion, let's say, of violence.
Thank you. The occupation question is one challenging thing. Last night in the discussion some of us had, there was also disagreement indeed over whether honking at a certain point becomes an assault. And is it, I mean, there is a physical dimension. Your body can experience noise if it's loud enough and sustained enough. And there are all kinds of norms around construction work and so on that recognize the impact on the person. Does that itself become unpeaceful at a certain moment? And I don't think of it as a political ideology, but whether you were in Ottawa last winter seems to affect a little bit how you approach some of these issues where conceptualizing and fact meet up. Professor McDonnell.
I was just going to add that one of the things that we have been discussing and will continue discussing in this conversation is the extent to which, because, as Professor Cameron points out, there is so little case law on freedom of peaceful assembly. When we're looking elsewhere for guidance, one of the places we tend to look is at the way that the court has addressed other fundamental freedoms. And here on this question of violence or threats of violence, the freedom of expression jurisprudence has moved from saying that, it's only physical violence that is sort of excluded from freedom of expression where there is communicative content, to including threats of violence. And so in terms of thinking about what the scope of peaceful assembly would be, my sense is that's a fairly strong authority for treating both threats of violence and actual violence as being not peaceful for the purpose of 2C. My sense is the question that comes out of some of the submissions of the parties and from some of the material that Professor Cameron canvasses in her paper is there something more than that beyond threats of violence? Is there something about disruption, inconvenience that also would take a protest outside of the scope of being peaceful? My impression, though, and perhaps this isn't shared by the panel, is that it would be surprising if a right to peaceful assembly did not take account of threats of violence, and that this standard for rendering a protest not peaceful is actual physical violence. I think that would be out of keeping with the kind of the freedom of expression jurisprudence and the direction it's taken for much the same reason, informed by much the same rationale as one would see in the context of peaceful assembly.
Colleagues, we're doing this collectively. We've spent longer on this issue than we'd expected, but I think it's valuable. So, Professor Moon, I'm happy to go to you next. We're all cognizant that this is shrinking a little bit freedom of expression, but I think this has been very fruitful so far.
I'll say very little.
Please continue.
I wanted to kind of work through the notion of occupying a neighborhood a little more closely, because if what we're talking about are public spaces, public properties, the streets, for example, as opposed to private properties, then it strikes me that there is at least initially a right to protest in those spaces. Obviously, the residential character of a particular neighborhood can certainly and should play a role in determining what's a reasonable limit on that. It's one thing to parade down a street in a residential neighborhood demonstrating. It's another to remain there for an extended period of time, to honk horns and whatever. And it strikes me that that's very much a question of what are the reasonable limits as opposed to something more basic.
Okay, so thank you very much for the exploration of freedom of peaceful assembly. We're going to turn now to freedom of expression, paragraph 2B of the Charter. We've already had the suggestion that there's continuity in the sense of potentially a collective and a physical dimension to this guarantee as well. But we're going to continue with Professor Moon.
All right, so I now have 2 minutes is what you're telling me.
No, you're good.
All right. Well, thank you. I'm, very pleased to be included in this. I almost feel like I should begin with an apology to the translators because I haven't often spoken to parliamentary committees, but on the few occasions I have, I've invariably been told to slow down. So I will at least try to begin. All right, so Section 2B of the Charter protects freedom of expression, but more fully, it protects freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. But I am going to simply speak about freedom of expression. It's generally understood that it matters, it's important as a fundamental right of freedom because it's necessary to the I know, it's, passion. It's necessary to the operation of a democratic form of government. It contributes significantly to the development of truth or the growth of individual or collective knowledge. And it's important to self-realization. I would add, though, I think it's important to keep in mind that freedom of expression doesn't just protect individual liberty in the sense of the individual's kind of personal, private space. It protects a social activity. It protects the right of an individual to speak to others and to hear what others may say. It's a social activity that invariably involves the use of collective resources, whether that be the parks, the streets, or the internet. And I think that's important to keep in mind. All right, the scope of freedom of expression. It protects communication, something along those lines. And what our courts have said, it protects any activity that is intended to convey meaning or a message to others. And I think it's worth noting that the court illustrates this with the example of parking against the rules. So ordinarily, if you park contrary to whatever the rules may be, presumably you do so because you don't want to pay, whatever might be the cost of doing so, or you can't find a convenient spot. But, says the court, if you park against the rules in order to protest in some way, then that counts as expression. Now, that suggests a fairly broad understanding of expression. In principle, any act can be an act of expression if performed with the intention of communicating a message. It also means that any law could, in theory, be a restriction on an expression if it happens to restrict the way in which someone has chosen to express themselves. Now, the example given by the court refers to parking. Maybe it's convenient that we're thinking of cars, but we could, of course, think of other vehicles as well when thinking about acts of expression. As Professor McDonnell earlier referred to, the court, though, recognizing the potential breadth of the scope of this right, has said that it doesn't include acts of violence. That's what they said initially, and then subsequently said, and it doesn't include threats of violence as well. So if an act involves, doesn't exclude advocacy of violence. I mean, that can be dealt with under Section 1 potentially, but from the scope of Section 2B, it only excludes acts that have the form of violence. So a terrorist act, some kind of physical violence directed at another, and threats to do so. All right, so the court has said that picketing, advertising, hate speech, obscenity are all fall within the scope of Section 2B, but of course are subject to reasonable limits under Section 1 of the Charter. I won't say anything more about Section 1 because it's been very well covered already. But maybe one thing worth noting is the court said with regard to freedom of expression, when we move on to Section 1 and considering limits, although all these different forms of expression are protected, some have more weight or more value than others when we are considering limits. So, for example, political speech, it's core value speech, is closely, says the court, connected to the values that underlie our commitment to freedom of expression. And so it has a high value. It will be harder for the state to justify its restriction. On the other hand, hate speech, obscenity, commercial advertising are less directly connected to these values, and therefore it may be easier for the state to justify its restriction. Okay, I wanted to quickly talk about three issues, free speech issues, that might be worth considering. One of them is hate speech. And in Canada, hate speech is restricted under certain human rights codes, not all of them, and at the moment, not under the Canada Human Rights Act, but that may change at some point. And it's restricted, of course, under the Criminal Code, under Section 319(2), which prohibits the willful promotion of hatred against the members of certain identifiable groups. There are two kinds of harms that we can connect to hate speech. One of them is the harm directly experienced by members of a target group. Threats, intimidation, harassment, for example. And most of the US cases are about that kind of harm. The other kind of harm is the spread of hateful views within the larger community, so that some in the community may be persuaded by others to take a particular view about members of the group, with the result that those who hear these views may adopt more hateful attitudes or may even take action against the members of targeted groups. And most of the Canadian cases have been concerned with that kind of harm, with hate speech laws directed at that kind of harm. And our courts, in a number of cases...
About 2 minutes left.
Okay, I'll get there. So our courts have been willing to uphold these restrictions on hate speech, focusing primarily on the fact that the laws are very narrow in their scope, focusing on speech that is extreme, that is understood as vilifying the members of particular groups. Okay, I'll say no more about that then. Another issue that seems relevant is the question of the right of individuals to access government-owned property in order to communicate. I wrote about this fairly extensively in my background paper, and so I'll just boil it down to this. Our courts have said that there are really two kinds of state-owned properties. There are what might be called public arenas or public forums, properties that by tradition or in practice are generally open to the public for communication, and individuals have a prima facie right to enter onto those properties in order to communicate. Obviously, their expression can be restricted for a variety of reasons, but those reasons are not simply that the state owns the property and can exclude someone from it. And then there are other properties to which individuals don't ordinarily have the right to enter onto and communicate, and they are described as paradoxically sometimes private forums or something like that. And the state doesn't have to justify the exclusion of expression from those properties. So we're talking about government offices, broadcast facilities, properties of that kind. And then I guess finally, I just wanted to say a little bit about social media and the changes that it has brought to our thinking about freedom of expression. I think one change is speech that previously was not considered harmful, at least to a degree that might justify its general restriction, we now may be viewing differently. For example, disinformation or deceit, of course, has been subject to very particular restrictions in the past, false advertising, defamation, and so forth. But it has become such a large problem, I think we are having to think increasingly about whether or not there need to be larger restrictions or interventions on this form of speech. And I think the same could be said about speech that is insulting or harassing. It takes on a different character online when so many people can pile on, or it can be persistent, or the insult or harassment can be widespread and endure in many ways. And then finally, I just want, my final remark is to say, of course, what social media also means is that the traditional legal responses to these harms are increasingly impractical. They're too slow, they're too cumbersome to really address these. And that's why there is much more thought being given to how social media can itself be engaged in taking this material down. And that brings a range of different challenges.
Thank you. Thank you. And social media, and disinformation will come back a little later this week. Professor Gautreau-Desbiens.
Yes, thank you very much. For the sake of time, I will speak directly to one issue that Professor Moon raised, which is that of disinformation, false news. And since I had written my notes in French, I will switch to French. Alors, je veux simplement rappeler. This has always been a challenge.
Avec vous.
Now, we must keep in mind that the very notion of fake news is ambiguous. It covers very different realities. We could be talking about hyped representations that are satires. It could be lies. It could be representations that are knowingly invented with a view to deceive. We know that in 1993, the Supreme Court invalidated a provision penalizing fake news, and the origins went back to the Middle Ages. At the time, the court said that the freedom of expression criteria often deal with opposition between the majority opinion about what is true or right and a minority and unpopular opinion. By putting into practice this relativism, which is behind liberalism, Judge McLaughlin at the time said that the freedom of expression is a guarantee. It's intended to protect the minority's rights to express an opinion, even if it's an unpopular one, etc., etc. So she was seeing in justifying the invalidation of the criminalization of fake news a way of protecting minority opinion. So that's the law. Now, we have to understand that Canadian law does not impose any truthfulness obligations upstream to whoever is expressing themselves. And it's important to say that in the legal discourse here. It's only downstream, after the fact, that the law can deal with people who don't tell the truth in very prescribed circumstances and hold them responsible for their fake words, for example, reputational harm. Now, something that's very important to point out here, I think, is that the expressive ecosystem in which we have been developing for the last 20 years with the internet, with the rise of social media, this is no longer the same context as the one in which we lived for 150 years. And so that other ruling was made in the old world before the rise of the internet. And what a great French sociologist, Pierre Savalot, said, the age of defiance versus the age of trust. So if we're going to continue to take seriously the Supreme Court's concerns regarding the complex nature of fake news, we must at the same time take cognizance of the fact, as Professor Moon said in his policy paper, that the framework is somewhat dated. This could be a bit of a Trojan horse, which would impede the truly complex apprehension of this new normative ecosystem. In fact, the ability to mobilize and take action with respect to disinformation strategy is now separated out so that any analysis of a demonstration such as what the Commission is looking at cannot really avoid making recommendations about what provokes upstream these sorts of demonstrations and what will provoke other protests. As my University of Montreal colleague Pierre Trudeau said, the various categories of fake news do not all give rise to the same interventions, but the ability to distinguish satire deals with promotion, comes from a strategy to promote the improvement of internet users' ability to read. But voluntary falsification of information could be dealt with by more stringent regulations. But we have to understand how social networks work through algorithms which are protected by trade secrets. And these are the very basis for the business model of social media. And so we know that this creates bubbles, information bubbles, which do not create a shock of ideas as classic freedom of expression theory would want. They are instead making silos between information universes, which are different. So there should be a limit potentially on social media operators' transparency requirements. Constitutionally speaking, of course, the court would have to do this in due course. I think it's important to revisit the framework for dealing with fake news, perhaps through the recognition of special status for what Harvard Professor Vicki Jackson called knowledge institutions, such as universities, museums, government statistics agencies that deal with the government at arm's length, courts. So these are social actors whose main objective is to analyze or develop, depending on what their particular goal is, to make reliable information filtered according to proven and verifiable standards. And even if we say that the distinction between facts and values is no longer as separate as it has been in the past, we must think about these issues. Now, I am afraid of saying that our constitutional law in terms of freedom of expression needs to come into the 21st century because maybe we're not there yet. The world has changed. Perhaps we need to review, even if it's based on very solid foundations, perhaps we have to review this sort of angelism which inspired it and which made us believe that ultimately the truth would triumph or could triumph. I'll stop there for now. I had many other things to say about, hate propaganda, etc. Well, okay, I'll say something about it. 30 seconds. I'm sure that the Dean will allow me. Criminalizing hate propaganda in Canada is done through identity variables, stigmatizing groups defined based on a particular identity, gender, sexual orientation, race, ethnic origin, etc. In our society, political polarization is exacerbated, and we see a lot of this traditional hateful propaganda. But there's always also the radical stigmatization, the virulent stigmatization of the people who are participating in the government activity, whether they're elected officials or whether they're part of the executive. These people are victims of virulent and often hateful attacks on social media because of their duties. And these are duties within democratic institutions. So there again, I think we have to question these issues. It's not the Commission, but rather the framers of the legislation who are going to deal with these issues. But this expressive ecosystem is all upstream and is very different from what there has been in the past. And that is going to favor the emergence of social movements, which may sometimes be violent. They won't always be. But they will mobilize people. And sometimes they may lead these people to do things collectively that could ultimately subvert democracy. I'll stop there. Thank you very much. There is some intersectionality here, because if you're talking about women in public service who are more often victims of these sorts of attacks, yes, factually that's been proven, that members of racialized groups who are in public service or women have more violence against them. Thank you very much, Professor de Gros-Devien.
And we have one more topic still, the relationship between the Emergencies Act and the Charter. So if someone has literally 2 minutes or less further on freedom of expression, I would be delighted to take it. But we collectively spent longer on peaceful assembly. Freedom of expression, a final intervention.
Obviously, everything was said that needed to be said, clearly.
Okay. Thank you very much.
Could
I take a moment to say that what was raised by Professor Bird intersects what Professor Gaudreau-Desbiens is saying in terms of tolerance of a protest. Do we have to consider the message that's being conveyed through the protest? And what about the consequences? Because we've heard in evidence that the message was encouraging threats, a lot of threats, towards women and politicians. So I think that's a question. It would be useful to me if you have any other comments to make about that, or perhaps to do that later on. Is it legitimate to consider that if expression is disinformation?
Panelists, is there an answer? Short answer for the Commissioner? Professor Gaudreau-Desbiens?
D'abord,
Well, as I've already mentioned, in the current state of the law, disinformation is allowed, and it's protected by the Constitution. And this is what the legal framework has. So to stigmatize messages would be a source for contesting because if the Parliament were deciding to pass legislation, let's say, in its areas of jurisdiction for communications, let's say, to tighten the constraints, and if this would in fact lead to hierarchization of information to give demonstrably true facts to come through more than fake news and disinformation, well, that in and of itself would likely be challenged. My thesis is that ultimately the traditional approach of which courts have adopted all over the place, in other words, being neutral with respect to the content, that's something that I think we have to call into question. We're not there yet, but I have the impression that we're moving in that direction. The maintenance of democratic spaces, which are the very essence of our constitutional effort, also have to be considered. There's a quote that I very much like, which is a classic in American constitutional law from Judge Jackson in 1949 in Terminiello. This was about freedom of expression. He said,
and liberty, it is between liberty and order, with order, and anarchy without either. There is a danger that if the court does not temper its doctrinaire logic with a little practical wisdom, it will convert the Constitutional Bill of Rights into a suicide pact. Et d'une certaine façon, je pense qu'on doit réfléchir.
I think, in other words, we have to think about the perimeters of the constitutional guarantees of the Canadian Charter in light of the fundamental value, which is democracy, which leads to freedom of expression. It's one of the underlying values. So if we're looking at the institutional continuum of rights in the Charter that are guaranteed, there's also the right to vote. Elections, at least every 5 years. And then somebody was asking about occupation. What's the kind of message that we want to be sending? If there's a radical change in regime, well, that's politics. The Canadian Charter is only 40 years old, and already we're looking at how some of it seems to be outdated.
And we have literally 5 minutes, so Professor Bird will share perhaps a comment or two on the relationship between the Emergencies Act and the Charter. Professor Bird.
Thank you, Dean Leckie. So in these comments, I just want to kind of intensify or amplify the radar with respect to how the Charter and the Emergencies Act converse. And so most of the commentary on the federal government's use of the Emergencies Act this year has focused on whether the circumstances in Ottawa last February amounted to a public order emergency. In other words, whether the federal government was legally entitled to invoke the Act. And this is, of course, a very important question for this commission, but it's also not the end of the story. This inquiry is tasked with investigating the circumstances that led to the declaration being issued and the measures taken for dealing with the emergencies. So even if the invocation of the Act was lawful, what about the legality of the measures that followed? This question looks beyond the issue of whether the federal government, either at this moment or any other moment in history, can lawfully invoke the Act. It certainly engages a downstream issue of whether measures taken after invocation fall within the scope of powers granted by the text of the Act. But the legality of these measures also implicates foundational considerations within the Canadian legal landscape. It invites us to think about how the Emergencies Act converses with the Canadian Constitution, and in particular, as we've been discussing today, the Canadian Charter of Rights and Freedoms. And so it could be perhaps tempting to think that the Act, given its substance and purpose and the stakes, transcends or somehow transcends the Charter. Put differently, if the federal government concludes that a given situation satisfies the criteria that permit recourse to the Act, its invocation, some citizens, maybe even the government itself, might slide into thinking that practically anything goes in responding to the emergency and that the Charter need not be consulted. But this way of thinking would be incorrect. The starting point is that every instance of state action in Canada must comply with the Constitution. To the extent that an instance of state action is inconsistent with the Constitution, the action is null and void. And this principle applies with equal force to the Emergencies Act, both in terms of the substance of the Act, its text, and decisions taken by government pursuant to it. The preamble to the Act actually refers to the Charter, noting that the federal government would be subject to the Charter when exercising powers granted by the Act. Now, to be clear, the Charter would still govern the use of the Act, even if the preamble did not mention the Charter. And as for why Parliament included this reference, perhaps it was intended to help us avoid that headspace described earlier, where the Act is somehow perceived as beyond the reach of the Charter. Now, it seems fair to say that in general, the substance of the Act does not unjustifiably limit Charter rights and freedoms. What I mean by that is that legislation that permits the state to take temporary but severe action to deal with extreme situations, insurrections, terrorism, and so forth, will certainly or almost certainly interfere with various charter guarantees like the ones we've been describing or discussing today. Even so, most, if not all of us, can agree that those interferences in those extreme situations would often be justifiable under Section 1 of the Charter. But matters become more complicated once the federal government actually invokes the Act and has recourse to the emergency powers at its disposal. Now, assuming for the moment that the circumstances on the ground satisfy the definition of a national emergency in the Act, it would be incorrect to suggest that each and every use of the powers in the Act that follow invocation will inevitably or automatically comply with the Charter. Even if an emergency as contemplated by the Act exists, each emergency is unique in nature. The federal government must therefore ensure that its use of emergency powers, depending on the features of the emergency at hand, limit charter rights and freedoms in ways that satisfy Section 1.
Thank you. Thank you very much. So we now have a little pause where we look at some questions, and then we'll come back for a final, much shorter session. Thank you very much, panelists.
The Commission is in recess for 30 minutes. La Commission est levée pour 30 minutes.
we have several questions. We'll begin with the one we wanted to address most importantly, I think. There may be a perception by the police this past winter that the Canadian Charter of Rights and Freedoms prevented them from, say, stopping the movement of trucks into parts of the city. And so we're curious if there are thoughts on how the Charter, and this is combining, I think, Section 2 and Section 1, so the Charter as a whole. I mean, would police have been able to stop truckers from driving through zones that were zoned as no trucks? Would the Charter have allowed police to stop people parking their trucks? Might the Charter have been satisfied if people were told to, park here and we'll bus you over to a different zone where you could gather?
Rights of trucks.
Wondering if you have thoughts on those.
Go ahead.
Okay,
Professor Moon will start.
I'll attempt that. I mean, I guess I have to preface any answer to that question with really what I think came out in our discussion, and that is people have the right to protest. Protest invariably involves some disruption of ordinary property use, and the question always is, what are the appropriate limits? And it's accepted that municipalities, for example, can put in place different kinds of restrictions, even notice requirements. If you're going to have a large protest, to inform the police or municipality in advance that you intend to do that. So I think the short answer is, I think they probably could do those things. They could say, no trucks parked in this area, no trucks can enter into this area. But it has to, notionally at least, be justified as a reasonable restriction on the right to protest. And certainly it strikes me, this is easy to say in hindsight, that it could easily be understood as reasonable, given the amount of space, the pollution, the noise, and so forth that a truck could generate. So again, the real challenge, and I don't envy those who have to make decisions here around any of these questions, is that ultimately it is a very practical determination to decide how much disruption, how long, and so forth. And it would not, to my mind, be unreasonable to say trucks in a space like this is a significant disruption, and the protest can happen, but it's legitimate to exclude trucks from it.
Professor Moon, if I could just follow up. You were talking about reasonable limits and so on, which is evoking the idea of a limit prescribed by law and so on. Do you think like existing no truck zone bylaws or whatever form those rules take, would that have been enough as the legal basis for the police to interfere with what they perceived to be the exercise of the democratic rights?
Without kind of having a sense of what the array of existing rules are that could be drawn upon, I think the answer might be yes, but I don't know enough about what the bylaws would be.
You're hedging your bets a little bit.
I am, absolutely.
Yeah, thank you. Professor Mathen and then Professor Cameron.
So I think it's also fair to look to past practice, and it is true that in the past there were protests and assemblies that did involve trucks, but they did not stay. And that seems to have been part of the landscape in which law enforcement was operating, but there was also information indicating that they intended to stay. And so had they taken that to be a real statement of intent that would pose a different kind of enforcement problem, then I think that would be the basis on which you could absolutely seek to prevent that mode of assembly. Again, it comes down to what does the fundamental freedom actually entail, but certainly given the scale of the vehicles and the information that was widely circulating about what was the intent for those vehicles, at a minimum, yes, you could in that context reasonably restrict them from proceeding in the way that they wanted to the positions where they wanted to place those vehicles.
I'm wondering if Professor Cameron has a different point of view.
I'm not sure what my point of view is, but I would just observe that in Toronto, I believe I'm correct in saying that the trucks were stopped from coming into downtown Toronto. And so the same kind of situation never crystallized in Toronto. As for Ottawa, I would say there's a significant difference between a flow-through demonstration, so where the trucks flow through in a day or 2 days and the trucks stay, as to whether and when they could be stopped. I'm not really sure. I would worry a little bit about prior restraint kinds of concerns were all trucks to be stopped and never given any opportunity to come into the capital city and make any kind of demonstration. I would worry a little bit about that, but it's an awkward situation, obviously, because once the trucks are there and they come in, the enforcement issue arises very quickly.
Professor Bird.
Just very quickly, just zooming out a bit, just strikes me that often other protests, thinking of marches where people are walking in the streets, maybe even kind of stopping in a city square or an intersection, oftentimes protests will involve abnormal use of a space. Normally people don't walk down major boulevards in mass, usually cars, and usually they'd be on the sidewalks instead. Sometimes that maybe even some cities, I don't know the array of bylaws, maybe even walking on streets, marching in streets might well also breach bylaws. So just to say that kind of abnormal use of public space for the purpose of protest seems to be quite common, but I agree with all the comments so far as well, very important.
So the factual question of whether there was prior notice of an intention to park might well be very significant as one thinks this through.
So, I mean, just to take this point to the next level, so there seems to be consensus that once trucks are parked illegally and are asked to leave and don't leave, would the assembly then become illegal, or is it an assembly that then is in violation of Section 1? Here they were allowed to park, and then they were asked essentially to leave and they didn't leave. So that's, I guess, that's the general view.
Well, so much to turn
Professor Moon.
as what the legal authorization would be to remove, and presumably there would be a variety of rules that would permit that. And then the question is whether that would be justified. And I think the consensus would be, particularly in this circumstance, it would be.
Professor Cameron?
Simply to add that on the question of reasonable limits, there are a number of variables. And as for the assembly itself, the general principle is that the assembly needs to be allowed to have an opportunity to present its message. So whatever that reasonable scope of time is, I'm not sure on the facts of this convoy, but then at a certain point in time, it becomes unreasonable for the vehicles to stay. So I think that's a fairly safe assessment.
Thank you, Professor McDonnell.
Just to say that I think this comment about the moment in time is quite important, because actually the requirements of justification under Section 1 may well be shifting as the situation evolves, right? And so this is my colleagues Colleen Flood and Brian Thomas have done some very helpful work on, in an emergency, in a situation like this, what is the court's response, or what's the response, of the state? It has to be connected to what's actually happening, what the facts are. And so that includes, like the situation and what's justifiable in the first 24 hours of the protest will be different than what's justifiable in week 1 and week 2, when you start layering in significant disruption and concerns about, the health and safety of others. Like this shifts the kind of the complexion of the justification analysis. And so actually that element of time is quite crucial and changes sort of what's permissible, right? And that, also changes the state's obligations, I think, right? So at the beginning, there's very little information about a fluid situation. The government has to make a call. They have to act, and they're entitled to act on the best information available to them, and they may not get it perfectly when they're trying to balance the interests of the community. And I think cases like Irwin Toy, which Professor Mathen sort of you adverted to without naming the case, but it's also in Professor Moon's paper. They're very clear that in these complex situations, the government is entitled to act without full knowledge, sort of in good faith. But as time goes on and more information becomes available, then the situation can change. And sometimes the state is under an obligation to kind of adapt its initial assessment of the situation.
The idea of this sort of changing situation, it's very interesting. It takes us a little bit off the initial question of the police, whether they were entitled to sort of stop the trucks before they came in. Commissioner, have you heard enough about the trucks?
No, I'll hear more about trucks over time.
We had another sort of specific question about the charter and what it requires of us. So the emergency measures regulations included a prohibition, as you'll know, on public assembly. A person must not participate in a public assembly that may reasonably be expected to lead to a breach of the peace by the support of the threat or use of acts of serious violence against persons or property. And it also said that a person must not travel to or within an area where such an assembly is taking place. So persons prohibited from entering the area where an assembly might, reasonably be expected to lead to a breach of the peace. Are there views over whether these rules in the regulations would appear to be, reasonable limits on charter rights? Professor McDonnell?
I'd be very curious to hear the thoughts of others, but it strikes me, at first blush that type of provision might well be might be overbroad, right? And so Section 7 of the Charter provides that individuals have a right to life, liberty, and security of the person, and a right not to be deprived thereof, except in accordance with the principles of fundamental justice. Now, to the extent that those provisions prohibit individuals from being in an area at all, they may, one of the principles of fundamental justice is that laws may not be overbroad, right? They shouldn't capture more people than the objectives of the provision are aimed at. And so it may well be that that's the kind of provision, that provision wasn't sort of sufficiently tailored. That's a possibility.
Thank you. We've got Professor Mathen and then Professor Cameron and Professor Bird.
So I think in considering this question, which on its face, it does look to be overbroad, it is important to consider the very definite time limits in which the Emergencies Act operates, which is essential to its core feature. And that will factor into whether in the circumstance that kind of prohibition is in fact overbroad. I would also point out that with respect to the prohibition on travel, I believe it was accompanied by a series of exceptions.
Okay.
Yeah,
That
exemptions, yes.
And were those criminal?
Exactly.
Were those criminal prohibitions?
Professor Mathen, just a second.
The exceptions?
There's exceptions, and we're asking whether those are criminal.
Yeah, they're offenses.
They're offenses under Section 10 of the regulation. Professor Mathen, did we cut you off? Did you finish?
No, I just wanted to say that there was some tailoring of the specific travel, the precise mobility restriction was also accompanied by exceptions. It doesn't obviate the fact that some people would have been prevented from travel, and that was indeed the very intention of the regulation.
Yeah. Thank you. Professor Cameron?
Thank you. Just a discrete point, which has to do with the designation of protected places and the potential over-designation of protected places, in particular Section 6F that allows any other place to be designated as a protected place by the Minister of Public Safety and Emergency Preparedness. I just have some concerns about that provision and its consequences for public assembly and other charter rights, including freedom of association, those who might wish to associate with a valid, viable assembly. Thank you.
Thank you. Professor Bird?
I was just going to say that, thank you, that the constitutionality of those regulations might also be informed by just the nature of the emergency. That it could be overbroad for the reasons stated by my colleagues on its face, but given the nature of the particular emergency in which they're being applied, it may not be, just depending on the actual application of just what's on the ground. And so maybe on its face, potentially some overbreadth issues, but depending on the nature of the emergency, it may end up not being perhaps an overbreadth issue at the end of the day once it's actually applied. Just a thought there.
Professor Bird, do you want to explain a little more? I mean, if someone were to bring a constitutional challenge to the enactment, they'd be challenging the written down rule.
Sure, no, absolutely. Thank you for that. I think that it may well be that a part of the analysis might be that given the nature of what's at stake in a potential invocation of the Emergencies Act, what the Act is meant to deal with, assuming that there has been a lawful invocation, public order emergency, public welfare emergency, et cetera, that might well inform whether the regulations that have been put to us are overbroad as well. So it's just the fact that we're dealing with an emergencies legislation, I think it also needs to be brought into the picture as to whether that overbreadth actually pans out. But I do also share the concerns of my colleagues that needs to be brought into the conversation too.
Thank you.
You can move on if you'd prefer.
Professor Moon, were you wanting to jump in?
I really just wanted to first reiterate what Professor Mathen said. Sorry, I keep saying it. And that obviously the temporary nature of it makes a difference. And secondly, I imagine a certain degree of deference is going to be given in a situation where rapid action is understood to be necessary. And obviously when we call it emergency response, then we would understand rapid action to be necessary. So it is obviously on the face very broad and would just in isolation be troubling. But I think those factors certainly would have to be taken into account.
Thank you. Okay, so we're going to move on. Is that okay to the next question?
Yeah, I guess we can. I guess one of the questions is, and maybe that's the overbroad that you commented on, but who makes the determination that it might lead to serious interference, et cetera? And because that's the, it's not clear to me, but that may be the answer, as Professor Bird said, that it's by its nature, because it's temporary and it has to be broad.
But there's a potential rule of law issue in the sense that there's a rule: you must not participate in a public assembly that may reasonably be expected to lead to a breach of the peace. How do you know when a particular assembly has met that threshold such that you're prohibited from going there? There are real questions about that.
Yeah.
Professor McDonnell?
I don't want to drag on the discussion, but there are actually just two very small points that I think are relevant to this overall discussion. One is that violations of Section 7 are very rarely saved under Section 1 of the Charter. So once established, they're very rarely found to be justified. But to the extent that the courts have suggested that there's an opening for finding Section 7 violations to be justified, it's in an emergency situation. And so, one of the things to recognize might be that we may acknowledge that on the face these laws were overbroad, but this very important context that my colleagues have been speaking about is relevant under Section 1 in terms of understanding whether, a degree of overbreadth, which would normally not be permissible, might in a specific context where a declaration of emergency has been made in a time-limited way be found to be justified. And so that, I think, is important. The other quick thing, though, that is maybe in tension with this is, as my colleague Professor Bird pointed out, the Emergencies Act is pretty clear that the Charter continues to apply. And so there is a bit of a tension. All Charter analysis is contextual, does take its color from the circumstances, and here the emergency is part of the circumstances. But to my mind, that type of argument also has its limits because the Emergencies Act specifically keeps the Charter in play. And in fact, the model of emergency control that we have adopted incorporates the charter as an important safeguard. And so to me, that means, you know, I'm glad I'm not the one making the decision, because there's a tension in there.
Well, and that's why I raise it, is at the end of the day, when much of the concern is that the act is so broad and powerful, but on the other hand, it is charter compliant by its very nature. So the answer to questions such as this one are important because it arguably affects the initial decision, because the degree of, or you could argue certainly that the degree of interference with the charter should be taken into account in the initial determination of what the threshold for an emergency is. And
Yes.
I don't think they're detached, but I'm not sure. And that's why I'm curious about the response from you.
Other thoughts on this one? Professor Mathen?
Just because the question was raised, who's the decider, I did just want to point out the interesting separation of powers issues that arises here, because initially you have an executive branch determination, but it is in very short order subject to legislative oversight and the opportunity in various ways to contest that. And so again, referring to what Professor Moon said, the zone for deference here to the decision being made in extremis, literally, is something that I think could be useful to consider.
Thank you. So we'll take a crack at another question. And counter-protests are in the question here. So we're wondering, you've got someone protesting or an assembly is protesting, and then there's the prospect of a counter-protest that could bring violent confrontation. And so we're wondering, does the kind of realistic prospect of a counter-protest that will perhaps issue in violence, does that make the initial protest violent, or, you know, attach a threat of violence to it? Professor Cameron.
Thank you. In researching the paper, I encountered quite a bit of commentary on just this point in the international jurisprudence and so forth. And basically the position that's taken in that jurisprudence is that the authorities have an obligation and a duty to protect the primary assembly in those circumstances, so that where a counter-protest presents itself and poses risks to the viability and the safety of the principal assembly, is the duty of authorities to deal with the counter-protest and protect the assembly, which is an interesting point of view. We don't have much guidance in Canada, but that's what I found when I was researching the paper.
Thank you very much. Other colleagues on that one? Professor
It's hard.
Gaudreau-Desbiens?
Oh, sorry.
Oh, no, well, I think that this position is quite sensible and reasonable, actually. The duty that is imposed upon the state to protect the First Assembly, while not prohibiting counter-protesters to express themselves. So you can imagine a situation where police officers create a kind of corridor between the two, but it's a rather onerous burden. But still, both must have the ability to express their views while taking into consideration this duty to protect the First Assembly.
And perhaps Professor Cameron, I mean, so I hear you saying what you're saying in the literature. If the initial protest is seriously harming or threatening the livelihood of the potential counter-protests, does that in any way change their position?
Well, if there are difficulties with, we'll call it the primary assembly, then those can, if that's what you mean, then those can, of course, be addressed.
The primary assembly is blocking a bridge that is shutting down the workplaces of the potential counter-protests, so like they're not just people expressing a different point of view. Does that change it?
Sorry, they both might be subject to regulation, so we wouldn't rule out the prospect of reasonable limits on the primary assembly, but the counter protest would still be subject to limits insofar as it is confronting and escalating the situation with the primary assembly. That would be my view.
Commissioner, anything?
No, I think to put it a little more directly in context, it's suggested, for example, in Windsor that the road should be opened up and people's livelihoods was affected by the road being closed. And let's assume the counter protest wanted to open the road. To put it more concretely, and so they would be in that case, the police would be preventing people from carrying out their legal right to proceed through the road, for example. Gets a little more complicated, I think.
It's not, yeah, that's not exactly
Moon.
counter protest, I guess, in the sense it's an attempt to exercise what are considered to be the right to move and drive. Because certainly the starting point is everybody has the right to protest or counter protest and so forth. And then the challenge always is, if it looks like there'll be conflict, to what extent can the police manage that? And only in exceptional situations where it's just unmanageable given their resources could it be shut down. But the starting point always has to be both sides. But that's an interesting and challenging question about my right to exercise my ordinary mobility that is directly coming in conflict with what the protesters are attempting to do.
Thank you. We're out of time, so we're going to stop without moving on to the fascinating question of separating the acts of individuals from the Assembly as a whole, which we might otherwise have come back to. Thank you very, very much for your contributions.
Thank you. It's always fascinating to debate these subjects, and it's very useful for me to listen to the submissions and to hear what the questions of participants are. Thank you.
Thank you. The commission is in recess until 2 o'clock. La commission est levée jusqu'à 14 heures.
Tu parles dans ton micro. Oh, OK, alors.
Thank you.